The last panel of the day is on the public and private benefits of the MDL, and it is, you met earlier today Judith, and she's been a very active participant, and you all know her anyway, but I did want to, she's going to be moderating this panel, I did want to just say just a word or two about her. Judith is prolific. She has written and thought seriously about subject as so many subjects, so varied, from courthouse architecture to solitary confinement in prisons, in addition to all of the procedural matters that she is here to talk about. I think it's fair to say, well, maybe even if it's not fair to say, I'm going to say it, she is one of the most distinguished professors in the world on any subject. Now, where's Troy? That's better than you, isn't it? Judith?
Holy moly. Okay, I'm also short, so I'm going to stand here. But we're a little countercultural. There's going to be a clicker and a PowerPoint that David's going to help us start with. Because we thought it would be helpful to sort of both zoom in and out and understand something more about thinking about MDL's work in the federal courts, and of the federal courts' work in the world, and of the state courts' work in the world. Is there a clicker? Yeah. Great, okay, you're going to make it, so, oh, no, I just want to be sure. And could you tilt one screen? It's on that screen, but yeah. If I won't see there. It's okay. Well, you'll tell me if I'm, perfect, okay. Oh, now I can see it, okay. So there are some podiums that go up and down. Okay, so, I wanted to introduce the subject matter and then introduce a terrific group of panelists to talk some about courts are historically venues of publicity and dissemination of information. Jeremy Bentham, of whom some of us are inordinately fond, talks about publicity as the soul of justice, and that the judge, while presiding at trial, is on trial. So if we have this historic obligation and function of courts, our question is then, how does MDL fit into this picture? How does MDL change this picture? And to start with, I just thought it would be helpful to look at the federal court docket over the last decades, and what you'll see in terms of total number of filed cases, this is filings, is roughly 350,000 cases now, of which the bulk are now civil, more than 250,000 civil cases filed a year. If we look at what once was imagined for the federal courts, there was a long-term study of the projections of what was going to happen in the federal courts, and the big bar there was that, oh my goodness, says the turn of the millennium planning, we're going to have 600,000 civil cases in the federal courts. What on earth will we do? To which the answer is we don't. And so it looks like filings have been relatively flat and relatively stable at the 300 to 350,000 filings over the last, not in 2010 was it way spiked, but it was down. And if we look at a growth rate over the many years, and thanks to generations of Yale law students who've helped me build this up, but we just see that it's really not a growth industry in the federal courts. And now if we look at the numbers of pending cases in the federal civil docket, we're looking at about 340,000 pending civil cases in the federal courts now, of which roughly a third are in multi-district litigation composites. And if we disaggregate the MDL a little bit and take out a couple of the big ones, mesh and asbestos, the lines are two lines of MDLs, because over the course of the day, we've heard don't oversimplify MDLs or smooth them out, but instead see them as discrete, and some are small and some are huge, and so this number of a third has to take into account that they're not all the same. Now just go look for a minute at the pending caseload of federal district court judges around the United States, just a snapshot. Central District of California, 500 cases roughly per judge. Go down to the DC District Court, try under 200 pending civil cases on their, cases per judge on their docket waiting. Now, our MDL judges will tell us that an MDL judge when you have the whole big case, it's one case because it counts for the entry court judge's docket, not for the transfer court docket. But what we're looking at, and now I'm about to say something that's maybe heresy in the context of the federal courts, is to say it's not a very busy courthouse. It's a phenomenally well-resourced, gorgeously built, in some instances, thank you, Judge Woodlock, for the Boston courthouse. Spectacular buildings that are phenomenally empty, with hardly any trials, declining amount of bench presence, and enormous amounts of resources. Are there some very busy districts yet? Yes, but to the extent we're trying to say, oh my goodness, when we were hearing from Professor Brandt about the history of the founding of the MDL, how are we going to deal? We're dealing in an era of civil rights, increasing causes of action, Congress giving the federal courts more work to do, and how are they going to manage it? We need economies of scale. And right now, if you're going to justify MDL, it's not because you have so many overworked. Now, if we were actually doing immigration, where there's more than 1,350 cases per immigration judge, we would be talking about something very different. If we were going to the state courts, we'd be talking about something different. But in the well-heeled federal courts, the function of multi-district litigation is for many purposes, but not just as a docket reliever. Now, it's actually as a docket infuser, which is federal courts need MDLs the way that judges and lawyers need this for resources. And my placeholder for a chart here is that of all the cases filed in federal district court, in the civil docket, it's a quarter of the cases are filed by people without lawyers, and on appeals, it's more than half the cases. I'm not saying all those cases are MDL eligible in terms of being the kind of case that would be filed there, but this is just one way to glimpse that even in the fancy, rich federal courts, there are an awful lot of poor people. And if we're talking, and then we heard from Elizabeth Cabraser that it's, and others, that it's $1 million to try a products case, and we haven't talked about the cost of experts that are bundled into that, let alone the cost of lawyers and the like. For everybody, it's expensive to litigate anything, and there are people who can't afford lawyers at all. So now if we come into the group-based litigation here, around the same time as we heard from Professor Brandt, we heard all about the idea of the MDL and the class action coming into being roughly the same time. 66 class action locates judges at the front end for certification, and 68 locates MDL panels, which we'll hear much more about because we have experts on that, locating the question of judges at the front end of putting together these aggregations. Rule 23 also dispatches judges at the point of settlement. In the class actions at 50 conference a couple years ago, I was also saying Rule 23 under dispatches federal judges after settlement to oversee the post-settlement phase, and we see MDL as under dispatching, but in the common law, federal judges are making it up to do some control over attorney's fees in MDL and some control sometimes over settlement, and we have judges here who will tell us more. Judicial oversight of aggregation is one question. Aggregation helping judges have cases with lawyers who can afford to litigate them, if not try them. Now look for a moment. We've heard over the course of the day about the role of proposed legislative oversight of multi-district litigation, and this oversight would be for some, and these are slides that we may come back to over the course of the panel here, but judges, you'd have to show on a submission sufficient to demonstrate there's evidentiary support, alleged injury and the like, overseeing the lawyers who are litigating, and then telling judges you've got 90 days in terms of a clock. Then when you go to recovery, overseeing attorney's fees with the shall receive not less than 80% of any money. So we're looking at distribution mechanisms. This is the Class Action Fairness Act, so named by Congress, overseeing in 2017 proposed but not enacted. But as we'll also hear there and have heard, their proposals to the Rules Committee of the rule makers to do something similar to some of these things as well, in terms of limits on certification, limits on attorney's fees, limits on how you, and reporting requirements. Now the reporting requirements are, tell us what happened, and I can be a fan of some of these requirements because we need to know more. The question is, who bears the costs and when is it that these requirements are imposed? This is a way, and then to distribute the money so our other panelists may use it. This is what I've just done is tried to provide a preview of coming attractions on the panel. And that is because Margaret Williams, or Margie, as Professor, Dr., Researcher Williams here, who's at the Federal Judicial Center, knows a lot more about multi-district litigation than most of us because she's looked at it individually and in the aggregate. And so she has written a paper on the judges of the U.S. multi-district panel that can tell us something about who is on the MDL itself and who is appointed. And she's written a great deal about the allocation, use, and empirical work along with her colleagues. Emery Lee is here and will be also talking some about this tomorrow. So she's going to continue by explaining something more about MDL at 50. We're then going to ask Professor Brian Fitzpatrick, and I should have said you're at the Federal Judicial Center, and it's a great example of the resources of the federal courts to have such accomplished researchers in-house to be able to think about the federal docket and understand more about it. Professor Fitzpatrick, you're visiting at Harvard right now, if I have this right, from whence you went, where you were also a law student, has written a great deal about the utilities of class actions and is going to speak some about the costs and benefits of aggregation and authority, centralized and decentralized along the way. And after this overview, we then turn to two individuals who are judges who have both judged in class actions and multi-district litigation and thought about the role. And we're first going to have Judge Woodlock coming from the District of Massachusetts and a designer of a gorgeous courthouse with Ellsworth Kelly's, and Harry Cobb, doing beautiful courtrooms. And he's thought, and not just thought, presided over a major MDL involving poisonous kidney solution allegations, that if you were on dialysis, you'd be much sicker using the product that was being marketed, which has a European, for apropos the jurisdiction comments from the before, a European element as well, and has pretrial and management orders, and we've talked about the role of the judge, and he will talk more about it. The Honorable Shira Shinlin here from the Southern District of New York, who is now longer sitting as an active judge, but working in a million other ways and thinking a lot about the function and role of judging. And we'll also talk some about what role judges have and could play in class action and MDL in the structuring and function of who are the auxiliary personnel is at least one piece of the topic. And Allison Zeeve, who's from Public Counsel and is the head of its litigation, Public Citizen. Sorry, too many publics, not the lawyers for public. There's like 20 acronyms for groups that have different views, but sound the same from the large print. Has litigated many times in the Supreme Court around the United States. I was both here as a lawyer and commentator looking at the attacks on the function and use of litigation. And with that, by way of preview, I pass the clicker, if not the baton, and David, you're going to make the next PowerPoint work, and I'll get out of the way. But wait a minute, there's one more slide I have to click to. Here's the clicker. Okay. This is a terrific photograph by William Cliff, who's a fantastic photographer. It's of a state court. And this is to be a placeholder. I can show you graphs, but it's not the same as showing you that courts are poor, people who litigate them are poor, and if we want a public face and a vital function for adjudication, we have to understand how to respond to this picture as well as those charts and graphs. Now,
see if I can.
I'm really going to mix things up by standing. All right, well, thank you very much for the opportunity to participate today. As Judith mentioned, she asked me to be on this panel to provide some context for understanding the role that MDL plays in the world of civil litigation generally, so that's my plan for the next few minutes anyway. I'll start with a brief overview of the work of the panel over the last 50 years and talk about some of the proceedings that they've created, and then move into some of the areas where I don't think we've got enough attention on what is going on in MDLs and maybe where some more scholarly attention would be useful. In calendar year 2017, the panel received 60 motions for centralization, which was a decrease from the prior year where they had 74, and certainly down substantially from the peak in 2009 when they received 121 motions for centralization. This figure shows the number of requests for centralization since the panel was created in 1968, as well as, and it might be a little hard to see on the screen, a very faint 5-year average to kind of smooth out, as we've been talking about today, any bumps in the trend. It's fairly clear from the trend itself that in the decade after the panel's creation to about 1995, the trend was fairly flat, and after that it rose, at least until the last 5 years when it's gone back down again. All of this is really to say that lawyers requesting centralization, there's an ebb and flow to what they do, and there are ways that that's having an effect on the scope of MDL with respect to civil litigation. You might be asking what's driving this trend in motions for centralization, and of course, the decision-making by the panel plays a clear role in that. In the past decade, the number of motions for centralization granted by the panel has gone down, and relatedly, denials have gone up. But the major drop was between 2009 and 2010, which, as I just noted, was the peak of motions for centralization before the panel. It's not just that the panel is, it's not just that there are more motions for centralization and so that denials have gone up as well. It's that the panel is granting fewer motions as a percentage of all the motions that it considers. And this chart shows the grant rate over time for the panel. The past years show changes in the grant rate over time. This is due to a host of factors that are likely affecting the larger trends in civil litigation, including class actions and other forms of aggregation, as well as the types of motions that the panel itself has been asked to consider. In the past 50 years of the panel's existence, the majority of the motions that the panel has granted fall into basically 3 categories: securities, antitrust, and every empirical scholar's favorite category, miscellaneous. Over 50% of the proceedings that the panel has created fall into these 3 categories, and only 13% of the proceedings were products liability. So while most of the proceedings are in securities, antitrust, and miscellaneous, it's important to note that most of the cases within these proceedings are in products liability proceedings. So 13% of proceedings are products liability, but over 90% of the cases included in MDLs are in a products liability proceeding. So it's important to talk about the differences in the panel's work when we're thinking about proceedings versus when we're thinking about cases themselves. And this plays into the point that Judith just made about the percentage of the civil docket that's tied up in MDL proceedings. Of course, a lot of attention is paid to the percentage of civil cases, pending civil cases that are involved in MDL proceedings, which is what this graph shows. At the end of this period, which was 2017, it was about 37% of all pending civil cases were included in a multi-district litigation proceeding. But I feel like this percentage, which gets a lot of attention, really needs to be understood in context. First, it should be noted that the percentage is largely based on the creation of large MDL proceedings, specifically the mesh proceedings. In fact, 86% of pending MDL cases are pending in a proceeding of 1,000 cases or more. That's what the MDL panel refers to as a large MDL proceeding. And 30% of all MDL pending cases are pending in a mesh proceeding. In fact, if you look, or at least this is true from last month's report by the panel, if you look between 2012 and 2014, the number of pending MDL cases doubled because of these large proceedings. And all of this is really to say that the recent increase in the percentage of civil litigation tied up in MDL proceedings is an anomaly that's likely going to go back down when the mesh proceedings close, unless another mass tort comes along. A further point to add to this discussion of the civil caseload is that the comparison of MDL cases, of pending civil litigation and pending MDL cases, whether or not you're going to include prisoner and Social Security cases is kind of beside the point. The comparison is false, right? Because if cases weren't complex, they wouldn't be in the MDL proceedings. And by the fact that they're complex, they're supposed to take longer than your average civil case. But every time you make this comparison in the pending civil caseload and the pending MDL docket, you're taking a snapshot in time. The cases in the MDL proceedings typically take 2 years. The average civil case typically takes just over a year. So every time you take that picture, you're taking the same MDL cases year to year and a whole new crop of civil cases, which is to say there's probably a better comparison that we can make when we're talking about the scope of civil litigation and how it's tied up in MDLs. To think about a better way to do that, I think it might be more fair if we look at filing cohorts as opposed to the pending caseload. So for example, in fiscal year 2007, about 3,600 cases were transferred under 1407, and another 36,000 were filed directly in the districts with MDL proceedings. So that makes about 40,000 civil cases tied up in an MDL proceeding out of the 260-odd thousand civil cases filed that year. That's really about 15% of the civil docket, civil filings tied up in MDL proceedings in that year. And this is a very different story that you're telling about the scope of MDL relative to civil litigation if you look at filings than if you were to look at the pending civil cases. Additionally, it should be noted that while a large number of cases may be pending at any one point in time, the number of pending proceedings for the panel has actually gone down recently. Moreover, we can expect that the closure of the mesh proceedings will not only decrease the number of pending civil cases, it will also substantially decrease the number of pending MDLs because there are 6 mesh proceedings, and they will all close and substantially drop this number as well, and that's something to keep in mind too. As these cases are pending in federal litigation, it's also important to note that they're pending for a variety of reasons, some of which may be outside of the scope of the court's control. For example, when cases are in settlement administration, they're still open on the court's docket. They're going to be pending for a very long time, but there's relatively little that the court can do to move them through the settlement administration process that's going to make them move faster. And so that's something to keep in mind as well. All right, so I'm saying to not focus too much on the pending civil cases, and maybe there are other ways to think about it. Where can we shed some light on the MDL process? Where is more research needed? In my remaining time, I'd like to focus on what is happening when the panel creates an MDL proceeding, and hopefully it'll provide some context for the rest of the discussion that you're going to hear from my co-panelists. The creation of MDL proceedings has some effects that I think are more important than others, and I'd like to highlight just a few. When the panel assigns a case or a proceeding to a particular district, they of course change the location of the litigation. This dovetails nicely with what the last panel was discussing. We're going to leave aside for a second the effect that this has on the litigants, because I'm sure there are people who are far better adept at speaking into that than I am. But this decision to move the litigation has a substantial effect on the workload of the federal courts. The work of MDL proceedings is truly national. However, as we know, not all proceedings are the same, and the transfer of cases from one court to another for proceedings can create workload imbalances in the federal court. So this map shows that almost every federal district has had at least one MDL proceeding assigned to it. Some of them have had a substantial number. But we know, again, that some of these proceedings are bigger than others, and it's important to take a look at how the flow of cases has really changed with respect to MDLs. This is probably going to be a little harder to see on that screen, but if you look over time, some districts have been a larger part of the MDL process than others, and this figure shows kind of the flow of litigation from one court to another. The larger the arc, the larger the percentage of that court's civil docket that's been tied up in MDL proceedings. And you can see, perhaps if you look on the internet, not on that screen right now, you can see the flow of cases from one district to another. There's a little arrow where it's showing where the district is receiving cases from, and then there's a straight line showing where the district is sending cases out. The arcs are divided, like I said, proportionally, so you can see that there are some courts, even without direct filings, which is not included in this picture, some courts have had a larger share of the MDL process than others. Overall, though, some courts have been So since some courts have been more involved in the MDL proceedings than others, if we look over time, we can see how this balances out, what the net result of these transfers have been. And it's not been constant over time for all courts. Some courts move from being a net transferee court to a net transferor court and back again, while others are consistently in one group or another. This chart shows the court workload due to MDL transfers into and out of a district. And the courts are arrayed by those that have been historically the most undercredited, where they manage more cases than are actually counted through filings, and those that are most overcredited. We see here that Pennsylvania Eastern's caseload was substantially affected by asbestos, which we all know, you don't need a chart to see that. But that's not the only time that the court received a substantial number of cases. And while overall it's typically been overcredited, in more recent years it's actually sent out more cases through the MDL process than it's received. And that's noteworthy. If we skip down to the bottom of the chart and look at courts that were historically net transfer courts, you can see that even Ohio Northern, which lost a substantial portion of its docket to the asbestos proceeding early on, it's seen a rise in its MDL transfers into the district for a number of the more recent proceedings that they've had. So you may be wondering, why does this all matter? And to explain why, I'd like to talk a little bit about how we measure workload within the federal courts. And I'm sure this is going to be of great interest to all of you, but this is where I spend my entire day. Workload, which is to say the cases filed in federal courts, are an important component of determining the resources of the federal courts. And as Judith mentioned at the start of the panel, the cases that are transferred into a court under 1407 do not count for their filings. So they do the additional work in these cases, even though they don't get the resources under the workload formulas for the case, right? They're doing more work than they're actually getting credit for. For most purposes, the cases that are included in MDL proceedings are excluded from workload calculations unless the case is transferred back to the transferor court where they would receive some sort of credit for the processing of the termination of the case. But we know this happens less than 3% of the time, so it's a substantial amount of work that the court has given to another court. They rarely get it back but they still got the workload credit for it because they got it under the filing. All right, so the increase in direct filings that we've seen in the most recent years of MDL have had some effect of eliminating these issues of workload credit, but as we heard earlier today, they raise other issues about venue and jurisdiction, and then from the court's perspective, they can raise questions about case management, and that's probably a different panel discussion than the one we're talking about today. Relatedly, though, the assignment of MDL proceedings by the panel not only affects the workload of the court, and I would be remiss if I didn't say it also affects the poor clerk's office, who have to manage all of these cases as they're coming in, but they also alter the docket of specific judges. Of course, the proceedings are assigned with the consent of a chief judge and the transferee judge who's receiving the work, so it's not like it's thrust upon them unwillingly, but it's important to note that some judges historically have received more MDL proceedings than others. And whether that's because they had prior experience with complex litigation or whether they sit on a court that happens to get a lot of MDL proceedings, so their odds of getting one are just better, whatever that reason may be, the issue of unequal proceeding assignments is one that has been of concern to the panel recently. And they're making efforts to expand the pool of transferee judges. So for example, in calendar year 2017, the 26 proceedings that were created by the panel, 10 of them went to a judge receiving their first proceeding. So the panel has made real efforts to distribute the work to more federal judges. Those federal judges are increasingly a diverse group of transferee judges as well. They're more minority and female judges who are participating as transferee judges than we've ever seen before, and you're going to hear about that from some of the other panelists. So that's noteworthy as well. So we know that the creation of MDL proceedings can change both the court and the judge, but the question remains, does it really affect the outcomes in these cases? In prior work, colleagues from the FJC and I looked at both cases that were remanded from the MDL proceedings and those considered for MDL proceedings that were not centralized, and we compared both of those groups to the rest of civil litigation. The biggest differences we found were between the settlement rates of remanded cases and all other civil cases. Remanded cases settled at higher rates than other civil cases, and civil cases that were never considered for aggregation were more likely to go out on motion before trial. But given that the remanded cases are done with pretrial proceedings, it's not terribly surprising that they settled while the cases that were not done with pretrial went out on a pretrial motion. So the differences between the two groups of cases exist, but they exist in ways that we would expect to find. So there's not a lot of difference, at least in the early cases that we looked at, in terms of the outcome. So it makes me wonder whether we need to spend a lot of time looking at specific outcomes in the cases in MDL proceedings, or perhaps in the next 50 years of the MDL, we might consider shifting our focus, and this is where I'll end. Without other aggregate litigation available, MDL is the only resource for mass torts, which is to say that in the future we should expect a lot of very large MDL proceedings to continue to occur. Given that and the workload disparities that I've highlighted today, these are only going to continue to be problems for the courts to manage. And so helping the courts and judges know what resources they need to deal with these proceedings, especially the large proceedings, will be a fruitful area of research. If most cases settle, as we've heard mentioned several times today, it would be important to know what those settlements look like. And I don't just mean who gets what and how much and under what claims, but how long did the claims process take? What was the distribution around that mean? And what were the judges' processes for managing the settlement process? Can we learn more from the settlement data to know about how long the administration of settlement takes and how courts can better manage their dockets to understand the settlement process? It would also be helpful to the litigants to know the process through which their case travels. And since the focus of the panel is on the public-private benefits of MDL, I don't know if we know enough about the private benefits of settlement and what they are and how long they take, and that might be of use to future studies as well. Thank you.
We wanted to pause for a second here in case there was any questions or comments about data from either the panelists or others as we try to sketch the baseline or a line for thinking through. And upon pausing for that, okay. Professor Fitzpatrick is going to help us think more about what actually Dr. Williams just left off with, which was the question of thinking through the benefits and disutilities of aggregation.
Thank you, Professor Resnick, and thank you to all the folks at NYU and Yale for inviting me. It's an honor to be here this year. I do want to step back from the trees and take a look at the forest for a few minutes. Professor Bratt earlier today said that the purpose behind the MDL statute was to concentrate power in the hands of one federal district judge. There are benefits to that, but there are also costs to doing that. And on the 50th birthday of the MDL statute, it's a good time to take a look at whether the framers of the '68 Act struck the balance correctly between the costs and the benefits. I started thinking about the costs and the benefits of the MDL a while ago when I was called to testify before the U.S. Senate Judiciary Committee. They asked me to take a look at a number of different questions involving concentrating judicial power. They were mainly interested in nationwide injunctions, which we've heard a lot about, one district court issuing an injunction to shut down the federal government vis-a-vis everyone in the United States, whether they're parties or not to the lawsuit. But they asked me about several things, but they didn't ask me about MDLs, and I was surprised by that because if you're concerned about one federal district court judge issuing a nationwide injunction, I think you should be really concerned about MDL judges. Like a nationwide injunction, one judge is deciding a legal or factual issue for thousands and thousands and thousands of people. But unlike the nationwide injunction, you don't get an appeal from most of the decisions that your MDL judge makes. You can at least appeal what the district judge does with the nationwide injunction. So I thought it was appropriate to take a look at the MDL process and reassess it in light of these costs and benefits of concentrating judicial power. So what are the costs and benefits? Well, there's two obvious benefits to concentrating judicial power. One is efficiency. Rather than have 10,000 different cases pending across the country, we've got them all in front of one judge. The defendants save a lot of money, and not having to reinvent the wheel 10,000 times in front of 10,000 judges. The plaintiffs save a lot of money doing things once instead of 10,000 times. And I think the most important thing to the framers of the 68 Act was the judges save a lot of time and energy because there's only one judge that has to confront these pretrial matters instead of a bunch of other judges. So we get a lot of efficiencies and economies in terms of consolidation. We also get uniformity. Everyone is treated the same. The plaintiffs all are treated the same on general causation we've heard about. The plaintiffs' experts, the defense experts, they're either excluded or allowed. Summary judgment, everyone is decided in the same way or not the same way. So we get uniformity across plaintiffs with the MDL system. There are two big costs, though, to concentrating power. One is pretty obvious and one's a little bit less obvious. The obvious one is we get error magnification. So when one judge makes a decision for everyone, if the judge makes a bad decision, then everyone sinks at the same time. If we had a bunch of judges making these decisions, then each judge would only sink so many people with a bad decision. But now we're sinking everybody. We've got all of our eggs in one basket, and that creates a lot of risks for the parties. So error magnification goes up with consolidation, concentration. The other thing that I think happens with concentration is we're more likely to make a mistake to begin with. And the reason I say that is this. You know, we normally think that if we have a lot of different people thinking about the same problem over time, we get to a better answer on how to solve that problem. But if we have one person making the decision for everyone at one time, we might be skeptical about how good that decision is compared to the decision we might make if a lot of people looked at something over a long period of time. That's why we have believed for so long in this country in the common law method, trial and error. We learn from each other as time goes by, thinking about the same kinds of questions. We lose some of that if we've got one judge making all of these decisions on pretrial matters in the MDL. So those are some of the costs and some of the benefits. As a theoretical matter, we can't come up with the optimal balance between those costs and benefits. I'm not even going to pretend to try to do that here today. But I do want to make 3 observations about these costs and benefits in the context of the MDL process. First, there's no doubt if we didn't have the MDL, we would lose a lot in terms of efficiency. People have to spend a lot more money fighting out in individual cases. Judges would have to spend a lot more time. But with that said, if we didn't have the MDL, it's not as if there wouldn't be some economies that arose through more informal means. Defendants would find ways to economize on the defense across different jurisdictions. Plaintiffs would organize themselves through referral networks of lawyers, informal mechanisms of aggregation, informal mechanisms to achieve economies of scale. There would still be some economies gained even if we didn't have them forced upon the parties through the MDL. In addition, we're not going to have 10,000 individual trials, even if we don't have the MDL. Most everything's going to settle at some point anyway. So we're going to lose some efficiencies if we get rid of the MDL, but we're not going to forego efficiency altogether. Private parties will organize themselves in efficient manners on their own. Secondly, the MDL process itself understands the benefits of diversity of thought over time, and we see this in the bellwether process that MDL judges use to try to give the parties information about the value of the cases that are in the MDL. And so it does strike me that if we see how desirable it is to have a diversity of juries take a look at the factual issues within the MDL process, we should be able to understand why it might be appropriate to have a diversity of judges take a look at some of the pretrial issues that arise in the MDL. Now, on the other side, I will say that just because we have an MDL doesn't mean we lose entirely the diversity of thought on these pretrial matters, because of course there are a lot of cases that cannot be removed to federal court and a lot of cases that cannot be brought into the MDL and that remain in state court. And we do have competing interpretations of the various factual and legal issues that the MDL judge is deciding in those state courts. And so we still gain some diversity of thought even with the MDL process, because things are stuck in state court. So things are not all or nothing here. So, you know, when the one group that's not here at this conference that is often at these conferences is corporate general counsels. And when I do go to conferences and I hear from the corporate general counsels, many of them are of the view that the costs of the MDL process far outweigh the benefits, to the extent that I've heard some general counsels say they would rather have no consolidation at all than to go through the consolidation they have to go through today. Now, I don't know if they're being honest when they say that. It's easy to say. It's harder to pay the legal bills for not having a consolidated litigation. But I think it's fair to say that there's some dissatisfaction among general counsels with the current process. If we don't want to go as far as some of them say they want to go and get rid of the MDL, are there some other reforms we might consider that would push the balance of costs and benefits more in favor of reducing error and error magnification, even if it sacrifices a little bit of the efficiency and the uniformity of the MDL? So here are 3 ideas that we might consider if we did want to move the balance a little bit off of where it is today. So first of all, this was mentioned this morning unfavorably. I think there's more merit to the idea than the earlier panel suggested. Interlocutory appeals. Why not? If we're having one judge decide 10,000 cases with one decision on important pretrial matters, why not get a second opinion on that from a 3-judge appellate court? It'll slow things down. Yes, we're going to lose, again, some of the efficiencies. But it's important to get a decision that affects 10,000 people correct. So why not have a couple more people take a look at it to make sure it is correct? And I will note that when MDL judges decide pretrial matters that are dispositive against plaintiffs, they do have an ability to get an immediate appeal. It was mentioned earlier this morning a couple times. An MDL judge has dismissed an entire consolidation on a summary judgment motion. Plaintiffs can appeal that immediately. If the judge denies your summary judgment motion, you're the defendant, you have no opportunity to appeal that immediately. It doesn't strike me as crazy to ask for more interlocutory appeal options if we're deciding 10,000 plaintiffs' cases at one time. What about on the remand, when the cases do go back to the judge that originally had the case? Maybe we give that judge a little more freedom to reconsider things that the MDL judge did. We've been debating last night and earlier today informally about the freedom that the transferor judge has to reconsider things that the MDL judge has already done. We think that the law of the case could prevent a transferor judge from reconsidering things, but there's a lot of play in the joints of that doctrine, and so we think if a transferor judge really wanted to reconsider something, they could. But maybe we should be more encouraging and say you have more freedom to reconsider things, to get a second opinion on matters if it goes back. And the last idea, and I believe Professor Francis McGovern at Duke proposed this at one point, is why do we think that the cases have to be consolidated in front of one judge? Why couldn't we consolidate the cases in front of maybe 3 judges or 5 judges? We could have a panel of 3 judges that handled pretrial proceedings, or we could split the cases into thirds and give a third of the cases each to one judge. Again, we're going to lose uniformity, obviously, if we do the latter of those options. But again, we get more people thinking about these problems before we lock an answer to the problem into stone. Thank you very much.
So now, thank you. We're going to have, Professor Fitzpatrick has sort of raised questions for judges. he said, why this and why not? So why not ask Judges Woodlock and then Chin, Woodlock responding first, and then to the management, some of the management issues, and then turning to the composition.
Well, I don't have to answer specific questions. That's the joy of the job from those on the outside, but I do want to reach them at some point, but not now. I want to talk about the overarching concern that Judith has raised, the publicity question, because this is a mysterious process, much more mysterious than any other process, I think, in the panoply of aggregate litigation. The most mysterious, meant to be, I think, by the parties who manipulate it. Everybody's introduced themselves so far, at least the judges have, is by their avatar. I guess I am Lucille Ball. But I think in this context, a better way to look at me, maybe raise the bar a little bit, is to say I'm like the fellow in Plato's cave. I see the shadows. I'm not exactly sure what it is that's generating those shadows and what the people are doing behind my back. And I think that's shared by the judicial panel. So let me use my most recent MDL case. I've taken MDL cases for quite some time. I've always taken the position I'll take one in a new category each time. So I got a call from one of the members of the MDL who said, we've got a products liability case for you. You want to do it? I said, sure, I'll do it. And just as a throwaway, I said, so how many cases in it? He said, 100. There's 4,800 cases 6 months later. Now, he may have been lying to me, or he may not have known either what this was going to generate. But the point, I guess, is the judges may think that they have significant role here, but the significant role is really being run by the plaintiff steering committee and the ways in which a defendant, in my case, this particular case, it's only one defendant, respond and set up these proceedings. I want to talk about 3 points of inflection in the proceedings that I think are particularly meaningful and perhaps illustrate how little power, authority the trial judge has in the MDL. And I want to emphasize, of course, all of you know that all judges are the same. They all have the same attitudes. They all have the same approach. But you might say that within that sameness, there's a wide range. You might have a Jack Weinstein, who, from Boston, of course, think of Larry Bird. Give me the ball. Then there are other people, maybe someone like me, who thinks that most of the time you lead from behind in this kind of litigation, or any kind of litigation. That the litigation is not about the judge, it's about the litigants and their representatives. Those artificial choices between the ends of the spectrum, of course, don't capture what's going on. You have to be nimble, you have to be responsive, so let me turn to the inflection points. Every so often, some benighted soul comes to me, or through their parents comes to me and say, what's the secret to success in life? And my response is almost uniform, which is mordantly stated, I suppose. Prudent selection of your parents. That probably captures the idea of privilege pretty well. It also captures what is success as an MDL judge. Prudent selection of your plaintiff's steering committee. Now, sometimes you have to do a lot of selecting. I've been fortunate in the most recent case, not to have to think about that because it came more or less without dispute by quite experienced attorneys. Sometimes people, ask, how do you figure out whether you can rely on them? Well, I started my work life as a newspaper reporter. I worked as a criminal investigator in the U.S. Attorney's Office. I like to go through 5-figure exercises of investigation, so I do some of that, and I came back, and it was clear that I had very good people who knew what they were doing, perhaps to distinguish themselves from me. So what I have is a group of people who are going to organize this thing for me, as to whom I'm not going to get very much in the way of objections, for whom I'm likely to lead from behind. But I also have a pretty keen sense of smell, and if I smell something in a case, I'll probably stick my nose into it in some particular fashion. But the overall goal is, I think it was Professor Lahav, but I perhaps missed it. I'm looking for someone who's capable of delivering horizontal equity. I'm looking for somebody who's concerned and has at least accommodated intellectually and ethically the principal agent question. I'm looking for somebody who's going to be able to facilitate a global settlement, because that's where these cases go. Now, I'm like Judge Kennelly. I'd rather try cases than manage, but I have a job description, and the job description now uses rules of case management, and that's the writ that I was provided. It is, I think Professor Witt had it right, this is tort law by private administration, in which the judge is there perhaps as a light-handed form of adult supervision. There's a second inflection point. That's the question I'll call marshaling of cases. It is trying to carry out the writ of whatever it is that the MDL panel did, even if they didn't know how much of it they did to me. So I'm looking at what it is that they sent to me and saying that's got to be the focus of my attention. And that means a need for coordination, because now we're talking in products liability cases of diversity cases. A number of the other MDLs I've had have been federal cases. And frankly, an MDL like that is no different than if 5 separate lawyers filed in the District of Massachusetts 5 separate securities cases. I consolidate them and pull them together. It just happens that they filed them around the country, but I'm not thinking about questions that diversity cases raise, questions of federalism that diversity cases raise. So what's involved here is a need for coordination. Now, Bristol-Myers, which came at the end of, just before the settlement was completed in my case, and might have would have generated a substantial amount of litigation at an inopportune time in the coordination of the case. Wasn't so much an issue, but even with Bristol-Myers, one has to think very seriously about questions of conflicts of law and the proper coordination of all of this. What you have is, and had in my case, ideally is an ability to work well with state court judges. After Bristol-Myers, there may not be so many state court judges who are going to be handling these cases, but the case I had the home base for the defendant in Massachusetts. That meant that if somebody didn't really want to be in the federal court, they filed in Massachusetts, but they could still be almost as close as the 2 courthouses in San Francisco in making a place to call home. Now, we have to understand, I think you all do, but maybe I can speak from the trenches, we have a segregated bar. And particularly in the area of products liability. For the most part, there are a group of attorneys, have been a group of attorneys, consistently been a group of attorneys who only want to practice in the state court. And then there's another group of attorneys who will practice in the federal court. And it may even reflect certain class biases or law school biases, but in any event, it's a fact. And as a consequence, 2 separate plaintiff steering committees arose in Massachusetts, one for the state court, one for the federal court. Again, I'm in Plato's cave. I'm not exactly sure how this happened, but I got my ideas. In any event, they worked well together. That was the genius of this case, I think. And I felt I had an obligation, and it came easily to me in this one, to work with the state court judge. State court judge, in fact, was someone who would appear before me in products liability cases on a number of occasions, and someone I had a high regard for, felt comfortable with, and so we did coordinated kinds of proceedings. It's not unusual, it happens from time to time. But for instance, for the Dobert hearings, we sat for a week in my courtroom, both on the bench, hearing the various experts. I'd step out of the room if it was going to be an expert who wasn't going to be in one of my cases. He'd step out of the room when it wasn't going to be somebody in his case. We made separate decisions because while you can say it's all federal law, yeah, it's federal law, but it's inflected by, your Dobert judgments are going to be inflected by the questions of what is it that state law would view as elemental and material, even though you go through this process. In any event, we both reached separate decisions that happen to be coincident. I do want to talk a bit about the idea of wink, wink, nod, nod, or judges are ignoring questions of choice of law because they're just not material or they're not thinking about it very much. I don't believe that's the case. There are questions of choice of law that frequently arise that even lawyers don't recognize, and they let it go so they don't become salient. But there are questions of choice of law that are critically important, and it seemed to me in my cases that I ought to, because I was dealing with not just Massachusetts law, but more generally, that I had to, at the front end, provide some indication to the parties of what I was going to do in choice of law cases and pick out something, some salient issue that could give them both a sense of what choice of law was going to be, how choice of law was going to be dealt with, and more particularly, how to deal with some specific issue. That was statute of limitations issues. Now, this is, leading from behind in the sense that I wouldn't have done it if the parties weren't open to it. They were busy. They had their own structure and they were working like little beavers out there. And I needed something to do to keep me interested in the case. So I raised that as a possibility. They seemed open to the possibility. So I did a couple of decisions on choice of law in the context of statute of limitations, where there is maybe more than one basket, more than 3 baskets, and the parties should understand what's going to happen to them. That also inflected another part. That is the question of direct filing. I provided a kind of open textured, and it never has been fully examined because it didn't have to be, but an open textured opportunity to recast your home forum after the question of statute of limitations and choice of law has been reached, so that someone says, gee, I might be better off if I were filing this lawsuit in the District of Massachusetts. It's going to be hard for me to do that in the District of Massachusetts now. I don't really have a basis for doing it, but I can designate the District of Massachusetts as a home forum. That may have been a way to, I won't call it smooth out, but provide a clear path to a more generalized determination. In any event, it provided a way of dealing with this question of how do you do direct filings for those who are late to the game, don't want to go through all of the process of going through the MDL, but just want to get into the thing and get it resolved. In any event, a series of modest choices that were made in response to the positions of the parties. What I ultimately was looking for, and it's been appreciated, I think, a little bit, or deprecated a little bit, is effective bellwethers. And we had a pair of bellwethers. That is, the state court judge had some, and I had some. And we coordinated the time. And we also had a trial schedule, much like Judge Kennelly's trial schedule that said, this one's going to go first, this one's going to go second, it's going to go back and forth between the courthouse in Middlesex and the courthouse on Fan Pier. And it was at that point that settlement kind of entered the ballgame. We ruled on the questions of Daubert. I think that it's fair to say that in the Daubert determinations, we were, let's call it latitudinarian. We were prepared to let everybody's experts, if they were in the ballpark, even if they might be there with a hockey stick, to testify so that the parties would get a sense of what their best case might be. That's a publicity issue, I suppose. It's also an issue that can be tidied up by Rule 59.
You're down to 2 minutes.
Okay, so I'll leave to settlement, which is frankly the end of the ball game for everyone. It was done by counsel. It was done as a private settlement. Because I could figure things out, could figure it out kind of, but it's not on the record. But one thing popped up in the course of it. For whatever reason, and I think it had to do with the politics of plaintiffs' group and the concern that plaintiffs' group had for selling their case to less than enthusiastic parts of the plaintiff group, they wanted to have some judicial officer involvement. Not much. The whole point of, I think, and maybe the genius, or at least what drives people in MDL cases, is that the judge won't be mucking about in settlement, won't get in the way of it, won't interfere with it. Now, there are ethical reasons that we all should talk about, we have talked about, that are important here, but by and large, I think that's an attraction of the MDL. Nevertheless, there were at least, I think, some members of the plaintiff group who wanted to say some judge should sign off on this. That will give it gravitas, that will do something like that. My suggestion was we'll do it by a special master. They had a special master, Eric Green, who was doing all the matrices for this, making all the choices. And I said, okay, what I will do is I will handle any appeals from the special master against the special master standard, which is a very demanding standard to have the special master overturned, against all the rules that the special master imposes. And so the special master imposed various tight rules about what was going to happen with what kind of evidence you could submit to the special master for the allocation. 4,800 cases, Judge Kirpolani in the state, and he had 8,500, I should add, cases. He had no appeals, I had 10. And in fact, I reversed on 2. Not big money, but apparently something, a kind of good housekeeping seal of approval that permitted it. Now, that goes back to the idea of how active is the MDL judge? Well, as active as the MDL judge thinks he should be, in a context in which people don't really want to have the MDL judge have that much power. Might exercise it, might say, give me the ball. That's a choice of judicial philosophy. So
we'll get our next judge and see how the judicial philosophy works.
Well, no, that wasn't what I was going to speak about. But when you first said after...
I think closer to the microphone.
Okay. After Professor Fitzpatrick finished, you said, did we have a response? So I thought we were going to do that before our more formal presentation.
Go ahead, go for it.
Yeah, very briefly. And then I want to get into my formal presentation as quickly as I can. But I appreciate the risk of this one judge having so much control and so much power. But I think that there are some checks and some balances to that, a couple of which you did mention. One, you certainly mentioned state courts, and that's been mentioned again. And in mass tort, that's more likely than any other kind of MDL. There's also been multiple MDLs. I think you mentioned in MESH, Margie, that there's 6 different MDLs. I don't know how that happened, but so be it. So that sometimes happens. Sometimes there are successor judges. Unfortunately, judges, like everybody else, die. Sometimes they retire. Sometimes their MDLs are passed along. So occasionally we do have successive judges. We also occasionally have 3-judge type panels. That has happened in the history of MDLs. We do have, as you pointed out, appeals from time to time. And while it may be the plaintiff appealing the dismissal, once the appellate court rules, it does create some further look at the legal issues around the country, so that's good too. And finally, the last check is trials. I know that the disappearing trial is a subject that's been well addressed at NYU and in this room, but occasionally there certainly are bellwether trials, which does help to sort of affect or counter the single judge issue. So I did want to say that while I see the risk, I think the benefit outweighs the cost. Now, I want to get to my topic, and I apologize up front. I have the soft subject. It has no academic basis at all. It is not doctrinal. It doesn't talk about venue or jurisdiction, but it does deal with public perception. So my topic is not the appointment of MDL judges, which Margie again touched on, and we know that's getting better because the JPML has decided to really focus on diversity. But I want to talk about the selection of counsel, and particularly the whole topic of diversity and inclusion, which you're not getting D&I credit today. I'm sorry about that because my talk could give you that credit, but it is a major issue in today's legal world, and I'm going to focus particularly on women and talk about that, whether the selection by judges of counsel and of court adjuncts is really moving in a direction that we can be satisfied with. So to do that, I have to set the table a little bit quickly, and I know we're running late. I will not take responsibility for that, but we are, so I will talk a little faster than I usually do. The background fact is, of course, that women have been more than 50% of the law school class for 30 years now, but that doesn't mean they're 50% of the profession at all. In fact, they're 35% of active lawyers. But as far as lead counsel positions, the ABA has done a study, the New York State Bar has done a study, which I authored, and we show over and over again that women are lead counsel between 20 and 25% of the time. The statistics are worse in class actions and in MDLs than they are across the board. So in class actions, women are lead counsel only 13% of the time. 71% of class actions have no women lead counsel. In MDLs pending as of April of 2014, men were appointed lead counsel 11.8 times more often than women. Although the statistics have improved in the last 8 years, now it's a 3-to-1 ratio, which is still not great. The BNA reported that from 2011 to 2015, women made up only 15% of all leadership appointments. Then it rose in 2015, but it dropped back in 16 and 17. Women are now at 22% of leadership roles in MDLs, which I don't find satisfactory. The rest of you can have your own views on that. Finally, there was a study published by Temple University Law School in 2017 that showed that men were 5 times more likely to be appointed to leadership positions in MDLs than women were. So let's take just 2 quick facts comparing MDLs and class actions. First of all, MDLs have more appointments that can be made, a larger leadership team. So there's much more scope for judges to consider diversity issues. Now, class actions in appointment of counsel have a rule, Rule 23G, which provides guidance for the appointments of counsel. Specifically, Rule 23G states that courts may consider any other matter pertinent to counsel's ability to fairly and adequately represent the interests of the class. So courts have very broad discretion. It's only reviewed for abuse of discretion, but we have no such guidance, no guidance at all in MDL appointments. So where do we look for governing standards? I can only find 3. The Code of Conduct for U.S. Judges, Canon 3B3, says a judge should exercise the power of appointment fairly and only on the basis of merit, avoiding unnecessary appointments, nepotism, and favoritism. That's all good. It doesn't really help us think about diversity. The Manual for Complex Litigation says the number of past leadership appointments is less important than the skills required to work effectively with the court and other attorneys. Experience, the manual says, is only one factor that a court should consider. The manual also specifically says that diverse interests should be considered. And then the only third area of guidance is something called the Balch-Duke MDL Guidelines, which used to be called the Center on Judicial Studies. And Chapter 2 of those guidelines is devoted to the selection and appointment of leadership in MDLs. It recommends, contrary to the example you just gave, that judges use a competitive process with individual applications rather than what's come to be called private ordering. Private ordering is when a proposed slate is submitted to the judge by the lawyers. But it urges judges to be mindful of the benefits of diversity and suggests that a judge should consider whether every leadership team reflects diverse interests. So why is this such an important issue now? Because the statistics I started with are dismal and they don't change. So for years we've been having the same, we women at least have been having the same conversation about the profession, and it's not really taking off after all these decades. Why is that? It could be implicit bias, something which is talked about a lot. I don't have time to explain that to you. Hopefully some of you understand implicit bias. It has a lot to do with stereotyping. It could be judicial inertia, which is called the repeat player syndrome. We give the appointments to those who've had them before. Or it could simply be benign neglect. Just go with the slate you're given, and rather than go through reviewing applications and holding a hearing. But I think we have to talk about the public perception of the integrity of the courts. And since we have talked about a third of the docket, in a way, being MDLs, it's important that the public perceive the process as fair. And I think people perceive it that way when it's not limited to one group, when they see people like themselves. Also, we know that diversity makes for better decision making. You even raise that in saying we should have more judges because the more diverse opinions we have, the better the ruling. Well, by the same token, a diverse team is going to bring something new to the table in terms of experience, values, education, just different points of view. And so a resolution encouraging diversity in appointments has been adopted by the National Association of Women Judges, the Defense Research Institute, which is the DRI, the defense side, the AAJ, which is the plaintiff side, and the Conference of Chief Justices. So many folks have been encouraging this. So what are the barriers to making this happen? Well, I've already mentioned implicit bias and can't do it in more detail, but it means that people prefer people who look like themselves. There's also something called confirmation bias, which means that you sort of stereotype people you think working mothers are too busy to be in a leadership position in an MDL, or women aren't tough negotiators, they're supportive people, whatever the bias is. Then there's what we call systematic roadblocks, such as the notion that to get these appointments, you have to have the experience and the financial resources, and that's a big one, financial resources. Most junior people don't have the experience and the financial resources, so it favors seniority, which generally means it favors white males. Then the issue is, are judges uncomfortable considering gender in making appointments, and should they be uncomfortable? Well, the answer to that is there's no clear precedent. We don't have case law on that issue. We know about compelling interest and strict scrutiny with respect to race in government action. We know about substantial relation to the achievement of important government interests when you're talking about gender. But does this appointment process reflect the equal protection analysis? My answer is no, because no one's saying the appointment has to reflect the issue in the case or the clients in the case, but we're saying it should be one factor that courts consider, which takes us only to best practices, and because we're late in time, I'm just going to have to rush through those. But in terms of best practices, courts should always consider diversity, I think, not only in the appointment of counsel, but also in the appointment of court adjuncts, such as special masters. The application method does allow for that. It allows the court to do, I think, more vetting. Also, courts should monitor and supervise. So if somebody presents a diverse team, a year later, maybe courts should look at the hours to see if it was window dressing or if those people who are diverse are really doing the work in the case. Judges can pass individual rules, which they've been doing lately, saying if a junior attorney is going to argue a motion, they're more likely to grant oral argument, or they'll allow two lawyers to question the same witness. All of that gives junior attorneys the chance to have the experience. If a repeat player is chosen, maybe that repeat player can have a second chair who's a diverse person and give them the opportunity to have the experience so that they too can become lead counsel someday. Judges, I think, should go out into the community. They should speak to bar associations. They should try to, I think, stimulate the interest of everybody having an opportunity here. I think that's really about all I can cover, but I think you get my point. I'd like to see more diversity in these appointments.
Well, thank you. We're going to go, we started 10 minutes late, so we're going to go a bit late. So we have both time and a time for a bit of comment and question and answer. Alice.
Okay, well, I'll still try to be brief while still being the gloomy, dissatisfied perspective that I had intended. I wanted to talk about challenges to aggregation and the potential risks of aggregation. We've discussed throughout the day how aggregation is helpful in that it streamlines proceedings, it allows for cost sharing among defendants, it decreases the time and resources of the federal courts. But because, as in other spheres, an individual has more power when she joins together than individually, and because all else being equal, a plaintiff is more likely to find a lawyer to pursue litigation when the costs are lower as opposed to higher. Corporations and their advocates spend a lot of time and money trying to impose barriers on aggregation. So in the context of class actions, corporations' efforts have achieved considerable success. The Supreme Court's decision in Walmart, and I think even more so in AT&T versus Concepcion, the considerable litigation in the lower courts about the meaning or the importance of ascertainability, and other developments have greatly reduced the viability of class actions at the same time that the Class Action Fairness Act of 2005 has pushed more and more class actions from state to federal courts. So the bulk of class actions now are in the federal courts where they're subject to this sort of inhospitable environment. And all of this before we know the effect of Bristol-Myers Squibb, which, as we discussed, may have a tremendous effect on class actions or not. But with class actions increasingly under attack in the federal courts, I think MDLs are an increasingly important mechanism for aggregating similar claims, at least in the mass tort product liability context. For these sorts of cases, MDLs make sense, I think, regardless of what's going on with class action, sometimes makes more sense. It's a better fit sometimes for an MDL than a class action. But at the same time, aggregation in MDL is not I think, a good fit. I just want to note in many types of class actions involving other sorts of consumer claims that are super important, and because they're small dollar amounts, will probably never be brought if they can't be brought in an aggregated class context. Nonetheless, for mass torts at least, the barriers to class actions can be, I think, significantly ameliorated with the possibility of MDLs. That's an increasingly attractive possibility for plaintiffs seeking the benefits, the efficiency, the cost savings of proceeding in an aggregated forum, and therefore MDLs are also now a bigger target for those who would decrease access to the civil justice system for individuals. I think the effort to impose barriers on class actions is at bottom an effort to protect large companies from any liability at all, and so I think it's not surprising to see bills in Congress over the past few years that impose barriers to class actions that would actually make them all but impossible. A bill in early 2017 that Judith referred to, called without irony the Fairness in Class Action Litigation Act, would have imposed such, or would impose such onerous requirements on class actions and other types of litigation. So despite its class action title, the bill also takes aim at personal injury or wrongful death claims brought by 2 or more people, so as few as 2 people, and also MDLs. The bill passed the House on a party line vote without any hearings because upending the civil justice system really doesn't merit a hearing. But the Senate never took it up, so it passed out of the House in March 2017, and nothing's happened yet. So I just wanted to talk about some of the ways that some of the things, the proposals in the bill with respect to MDLs, some of which are similar to some of the things that have been proposed as rule changes. And I'm going to skip over my diatribe about the class action proposals. But I do want to mention the one about misjoinder. There's one called misjoinder, and
Not M-I-S-S.
MISJOINDER, one word, that provides that if 2 or more plaintiffs join together in a personal injury or wrongful death claim in state court, even absent diversity, it could be removed, and then say 2 siblings, one lives in New York and one lives in Connecticut, they sue in New York State court, it can be removed, and then it has to be severed. The New York plaintiff goes back to state court. The Connecticut plaintiff proceeds in diversity in federal court. Even if these are 2 siblings injured in the same car accident by the same person, it's just a way to make the litigation more expensive for the plaintiffs. At least if you can think of another reason, I haven't thought of one. For MDLs, though, the provisions of the bill would make MDLs, I think, pretty unattractive to plaintiffs and to the courts. One provision would, Judith mentioned this one, within 45 days, so on an expedited basis, the plaintiff has to present evidence sufficient to support her claim, including medical records. Presumably she'd have her own medical records, but if the judge then has 90 days to evaluate the claim, and if it deems these initial filings at the beginning of the case before any discovery insufficient, dismiss the case without prejudice. Within 30 days, if the plaintiff can't meet that standard, it is dismissed with prejudice, and that's the end of the case. So in this way, the bill would turn MDLs into a device for the defendant to get rid of potentially meritorious cases that couldn't be dismissed if they had remained in an individual case right off the bat. The bill would also add provisions for, actually one that Brian suggested, for immediate appeal of any order in a personal injury MDL. So Brian asked us why not. I think the answer is because defendants would appeal every decision in favor of a plaintiff, because that would be totally reasonable. In the best interest of their client, delay is good. There's no reason to push on to try to get to the end of the case. In a personal injury case, if you can delay it long enough, maybe the plaintiff will die. That was like totally cynical. I don't think that's generally, it's just delay for a defendant. That's what you do when you're a defendant in a case. You don't push the case forward. I also don't think that the inability for a defendant to appeal a denial of summary judgment, but the plaintiff can appeal a grant, is a reason to change the rules and make every, just to pick on Brian a little, to make every decision appealable. That's just the general rule from 28 USC final judgment rule. If there is some really important issue in the motion for summary judgment that the defendant's motion that got denied, they can ask the court to certify it under 1292B for immediate appeal. But there's not really a reason to change the basic rules of litigation in that way just because they're aggregated, or at least not one that I can see. And finally, the bill has sort of arbitrary limits on attorney's fees in MDLs that wouldn't be subject to the same cases if they proceeded in an individual way or were resolved on an individual basis. And again, I think that the Congress needs to give more thought before imposing rules and different requirements on MDLs than on other litigation. Though I may regret that, then they might just impose arbitrary rules on all litigation. Anyway, yes, I'm just talking about one bill that just particularly annoys me, and it hasn't moved this year. But proposals like these are certain to be introduced again and again, and different versions of them we've seen now being introduced in the House, at least, for many years in a row. So for plaintiffs, the benefit of aggregation is to make litigation more cost-effective. For courts, I think, it decreases the number of cases to be managed and decided. Potentially, the smoothing out effect can maybe be seen as fairer across the board. But for corporate defendants, aggregation is both an efficient way to litigate, but also an efficient way to eliminate large swaths of cases and therefore liability all in one sort of fell swoop, either by winning the case, but also by erecting barriers that make MDL litigation either not viable for the plaintiffs or a losing proposition. So when we talk about the public and private benefits, I think there's a potential for the biggest private benefit of aggregation to really be a benefit to defendants in eliminating them. And in that way, MDLs would sort of, in the name of efficiency, really lead to a loss of access to the civil justice system.
Judith, can I
So
make a comment?
I wanted to invite, we haven't actually all said the same thing or agreed with each other. So we're going to spend about 3 or 4 minutes disagreeing before we ask for questions.
Oh, actually, I wasn't going to disagree. I was going to say that's the legislative end of it. But I and 2 other people in the room served on the Civil Rules Advisory Committee over the years. And the Civil Rules Advisory Committee has created a subcommittee on MDLs. And I can tell you they are going to look at every one of the issues that are pending in that legislation, which hasn't moved for a year and a half to the Senate, so I think it may not be going anywhere in the legislative side. But if the Rules Committee decides to get serious about it, and there are proponents of those issues, such as the LCJ, the Lawyers for Civil Justice, the Chamber of Commerce, all the rest of it, are making very similar proposals to the Rules Committee, which is studying it. I know they move very slowly. It could take a decade if they do it at all. But I will say they are considering many of the same proposals that you mentioned on the legislative side.
There is a list of them. Do you want to?
Well, many of them were discussed.
Well, I mean, we could go through the LCJ list, but one of the things on the list was interlocutory appeals, and I just wanted to say a brief word in response to Allison on that. When I mentioned in my presentation we might give defendants more access to interlocutory appeals, I didn't mean to endorse unlimited interlocutory appeals. I think, we could limit the number of interlocutory appeals they get if that's your concern. I obviously understand that it's not the usual rule in our system to give access to interlocutory appeals, but we're not dealing with the usual case if we have a decision that affects 10,000 cases all at once. I think that's an extraordinary case, and maybe we need an extraordinary rule for those situations. Professor Resnick, if I may also respond to Judge Shinlin about the legality of judges considering race and gender when they make appointments. I have to respectfully disagree with the judge. I think if race and gender is one factor, just one factor, it still requires you to meet the heightened equal protection scrutiny that the Supreme Court has laid down. That's why all the affirmative action plans have to meet heightened scrutiny. Race is only one factor for college admissions, but it still has to meet heightened scrutiny. And in fact, Judge, I think it was one of your former colleagues, Judge Baer, did appoint class counsel in a case in part because of the racial diversity of the legal team would match the racial diversity of the class better. And it went up to the Supreme Court, and I think the Supreme Court did not take the case on whatever the issue was, but Justice Alito wrote a separate opinion, and he said he said that he found it questionable that it could be legal for a judge to appoint counsel in part because of the racial and gender demographics of the firm.
Yeah, well, it was a footnote. It was a single footnote by a single justice, Justice Alito, and it's distinguishable because Judge Baer said, that's what I'm going to do. I'm going to make that the sole factor. There has to be at least one member of this team who's diverse. That's not what I was talking about. I said very clearly to avoid that potential constitutional issue, so long as it is an A factor that is considered, I don't think we have that issue. As far as the college affirmative action cases, they're not yet decided.
Yes, we're not going to bore you the last few minutes. Go ahead.
I'm sorry, I'm speaking now for myself and not for the Federal Judicial Center when I said this, to probably preface that, but I think if we're going to talk about this public-private dichotomy, I think we need to recognize the fact that not having women on the Plaintiff Steering Committee when so many of these issues deal with women's health issues, I think that raises really important questions of legitimacy of the process to the litigants, and that's something that we should keep in mind. Again, that's me, not the Federal Judicial Center. I just wanted to point that out.
So in the, I argued the Mohawk case in the U.S. Supreme Court, which is about interlocutory appeals, so I can't help but talk for a second about, one is just that there's much more mandamus than one might think the formal doctrine says there is, so that in terms of when things feel outrageous, there's informal mandamus, as in, and I have a minor practice in representing some people, in informal mandamus, representing some judges, that you have, that there's a mandamus and then something changes at the district court level and it goes away. And then there's formal mandamus, and there's more than you might think under the rules of mandamus in a variety of these kind of procedural issues. Plus, of course, Allison mentioned 1292. There is a mechanism for asking to get up. So then the question is, should there be yet more of it? And also, would you stay things while there's more of it and the sort of muddiness in between in terms of the complexity? But I think the question about rate, I want to try to get rid of left-right for a second to ask about a regulatory structure, which is, we have judges with a lot of authority in individual cases as well as in aggregate cases. So I think that MDLs are less exotic than they get positioned, not just in terms of class actions, but also in terms of ordinary litigation. Judges have a great deal of authority and discretion. And then the question is, who should get regulated by Congress, by the Rules Committee, by themselves, by standing orders, to do what in terms of ends? And of course, one of my concerns is both under-regulation about important public decision-making, and I think across the panel, you've had different views. It looks like some nervousness about congressional regulation. Not complete, but some, both in terms of centralization, yes?
I wouldn't trust the House of Representatives to, you know, tie their own shoes, so yeah. I
Okay,
mean-
so just I'm trying to find our both disagreements and invite comment as well. The appetite for Congress is limited here. The question about whether rulemaking by the Rules Committee is probably more varied, and of course, the substance of those rules is enormously contested, even in this exchange. And I wanted to invite comments or questions, but did any of you else want to come in to disagree or agree with each other?
I
Yes.
hate to add my voice on this,
But,
but what's problematic from your perspective, and I think mine too, with the MDL is fundamentally structural, and it has to do with the lack of transparency in the process. That has to be changed dramatically if it's going to be changed. And I don't really hear a wellspring of desire for that by the participants in the process. Now, that isn't to say that those of us on the outside or in the cave should know more about it, but it's got to come from below in that structural way. As to the individual choices, I find myself in the same individual suggestions and various changes. I'm, as frequently happens, in the position of the Tory statesman who was asked whether or not he would support reform. He said, reform? Why would I support reform? Things are bad enough as they are. And that's generally my view about these various nits and picks kinds of changes that are being suggested, except that they are clearly based, the congressional ones are clearly based on a particular bias toward a particular constituency.
we have a comment there, a question. Stand up, introduce yourself, please, again, even if you
Hi,
have before.
David Knoll from Rutgers. So this is primarily for Margie, but I guess it's for the whole panel. Do we know anything about public perception of the MDL process or the experience of litigants who are pulled into an MDL, or whether people perceive this as an effective and legitimate form of government?
Well, from the center, no, we haven't done that kind of research. I think there are some academics out there that have begun to delve into these issues. I'd be happy to pass my names along, but from the center's perspective, no, we haven't done a lot of that. Looking at from the litigant perspective and like surveying them about their experience and how efficacious they felt. In some ways, that would be hard to do, though, right? Because they don't know what's behind door number 2. They only know what happened to their case in the MDL proceeding, and you can ask them questions about whether or not they think the attorney represented them and that kind of thing, but they don't know what the alternative actually was. So setting up a true a survey that could tease out those kinds of feelings of efficacy might be more difficult than could really be implemented in practice.
We're going to be able to preview and suggest tomorrow's panel on technology. I know Elizabeth Cabraser is going to be talking some about trying to engage individual participants in it, because one of the answers to your empirical question would be, we know lawyers individually retain plaintiffs' attorneys. Is what IRPAs is what we try to use as a term when there's litigation by individually retained plaintiffs' attorneys against class lawyers or MDL lawyers in terms of allocation of resources, but they'll be the individuals who will be the communicators to the litigants unless there are mechanisms through technology to engage directly in an information flow to the participants. Judge Breyer at the district court in the VW litigation called non-class lawyers. So there was class lawyers and non-class lawyers, or non-MDL lawyers and MDL. But if we try to look at the array of lawyers, there'll be mediating variables that you'd have to take into account unless technology, which we'll find out tomorrow or today, can solve the problem. Did you want to comment,
David,
Elizabeth?
I wanted to respond to David for
Yes.
1 second.
Yes.
Just on a macro level, we do have public opinion research surveys which say that how does the public perceive the 3 branches of government? And the numbers with respect to the courts is sinking. So,
And also at that macro level, we know from the studies on gender, race, and ethnic bias in the courts that subgroups understand themselves differently situated.
Correct.
So that women and men of color see themselves as less participatory, and there are examples, the DC circuits gender race bias task force. White men, how often were you as lawyers questioned about your status as a lawyer? 1%, never. White women and black men, actually a few percent. Black women, no one assumed that they were lawyers when they walked into that courtroom. So you see that the experiences vary, and you have some of that kind of concern in a fairly wide database about perceptions of the courts in general from subgroups.
I think we have time for one more question.
Robin Efron, this is really more of a comment. So not getting into the constitutional standards directly about diversity, I just wanted to point out what at least I think might be a gap, which is that all of the judges who are running the MDLs are Article 3 judges, which means that presumably the nomination by the president and the confirmation by the Senate are not subject to whatever scrutiny. So, just yesterday or the day before, we found out that the 20 new nominees for district and circuit court judges were all men. 13, right. So that's right. There were 7 other nominees for other positions in the federal government who were also not women. And I know, I take pride in my participation in activities across the ideological spectrum. I can name conservative women who could have been nominated by this president, and they weren't. And so the thing that I worry about is that the people who are doing the picking of the steering committees are themselves being picked in a process that, regardless of the administration, although I would say it's more true in some administrations than others, are largely picking white men, and then they're in a position in which the way we've set up civil litigation, I think for many good reasons, it relies on the sort of intuition and experience of judges to have this sort of melange in their minds as they're picking things. And I think it's entirely human and not surprising to replicate what you have seen in what you're picking. And so the thing that I worry about is, I'll leave it to the con law experts to tell me what the standards of scrutiny are, but I just want to know how we can design a system that isn't really replicating things that I think are taking account of race and gender, because that's how the systems were set up in the first place.
Do you have
Any
anything final?
responses?
I'd like to respond for a
Yes.
second, Judge Resnick.
There's Professor
Professor Resnick,
Professor Efron.
there were no women on the list of new nominees, but there were several people of color on the list that I know personally. So I think that we need to consider diversity more broadly besides just gender, but also race, and the new list had some there. And I would just say one more thing, and that is, when it comes to what the constitutional standard may be here, and I do think you have to meet heightened scrutiny, it doesn't mean you can't survive heightened scrutiny. The Supreme Court has found diversity to be a compelling interest in other contexts, and they may very well find it to be a compelling interest here too. I think it is a very desirable thing. And so my observation was just on what the legal standard was, not whether the legal standard could be overcome.
I just should actually add that the concern that Judge Schindler was raising is mostly about, and there's actually a law review article, I think, by Elizabeth Birch, and there's so much written about the repeat player insider activity of the MDL process that seems not to be a political spectrum issue, but a kind of inside the beltway set of repeat players that predates this president and the last president in terms of the demography and engagement of the bar. And so the kinds of concerns are long-standing. And then the question is, what world do you want to make in terms of what world we're in, and how, in terms of these litigations, which involve a great deal of power and a great deal of authority, how you make them as legitimate as possible. And we heard across the spectrum here a variety of different proposals to tweak it, and then maybe concern that in a world so hostile to adjudication in general, any of these proposals are going to be taken by, we should say the word, the Chamber of Commerce, to to not be engendering what everybody here is doing, trying to do, and I'm using the word engendering on purpose, but rather to be being destructive. So everybody here is saying, how can we fix it? How can we improve it? What's good about it? And there's some people out there who are trying to do something quite different.
So I want to, I think we all owe a thank you to Judith and the rest of the panel. Thank you very much.